All right, well, staying with legal matters, Judge President of the Gauteng Division of the High Court recently introduced compulsory mediation for all civil cases. This is in response to the overwhelming national caseload burden, where some trial dates have been scheduled to as far forward as 2031. According to experts, whilst the initiative holds promise in reducing the court backlog, its success will be determined by how effectively parties engage with the process and the availability, of course, of qualified mediators. So, Director of Dispute Resolution Practice at Cliffe Dekker Hofmeyr Inc, Burton Meyer is going to be joining us to unpack further. Very good evening to you, Burton. Thank you for joining us here on the SABC at this hour.
Yes, good evening, Liesl. Thanks so much for inviting me to join you this evening.
All right, so obviously context is important, and the rationale behind, this compulsory mediation directive. Tell us a little bit more about how this actually came to be.
Well, I think it's not the first initiative.
Sure.
I think about 2 years ago they introduced Rule 41A as a rule that required a mediation notice to actually go out at the commencement of proceedings with a view to the parties trying to mediate before the litigation even got going. That hasn't been too successful. It's really been an initiative that hasn't produced great results. But I think the main reason for the change and the introduction of the mandatory mediation at this point in time is due to the fact that the courts are just overloaded, particularly with regards to civil trials. Court dates are being allocated in 2031, and unfortunately, justice delayed is justice denied. And I think it's imperative that something is done to alleviate the congested court roll.
Well, absolutely. And so as we turn to the various solutions on offer and alternative dispute resolutions that have been put forward, tell us about the impact this is directly going to have on this compulsory mediation directive on the legal system in reality.
Well, I mean, the reality directly from the directive is that all trial dates post the 1st of January 2027 have now been removed. If you had a trial date beyond 2027, the 1st of January, it's been removed, and you now have to follow through a mandatory process, mediation process, appoint a mediator, run a mediation process, and try and resolve your matter. And conclude a settlement agreement, and only if that fails can you then approach the court again with a view to getting a new trial date. That's the immediate impact, and it's having an impact on all trial dates.
Okay, and I mean, now there's obviously some questions or more questions than answers at this point, because as we look at this implementation, obviously buy-in from clients and legal practitioners is important. I'm looking at the incurred costs as well. Perhaps pre-trial hearing as well, that's something that comes to the fore. But even just on the timelines itself, how is this all going to play out?
Well, I think if one follows the protocol, and that was one of the useful things that was provided at the time that the directive was issued, is that there is a protocol that's being provided, and it sets out a detailed process that needs to be followed. And it's envisaged that once the parties conclude a mediation agreement, that the process will take 30 days to run and conclude, and then you can once again approach the court for a new trial date. So it's not a lengthy, protracted process. And Judge President Malambo has said that once you apply again for a trial date, he will give you a new date within 18 months.
Okay, and then even on the basis of the mediators that are appointed, tell us about what goes into that as well, and the appropriate timelines that they would have to follow. I mean, we're just obviously looking at the system and the impact that the trust deficit has to date, and how that's going to be mitigated against.
Yes, no, definitely. I mean, there is a process that has to be followed. The mediators have to be appointed by the party initiating the mediation process. It would normally, in most cases, be the plaintiff, and he has to follow that process, normally within 5 to 10 days, propose a mediator. And what actually starts that process is a full Rule 41A notice. That's what they call an amplified notice. And in that notice, you nominate the mediators that you would want to appoint. and it's then within a period of 10 days that the other side then has to say they agree with that mediator or propose alternative mediators. And if the parties then can't agree within a further period, the parties then go to the umpire that will be appointed by the High Court in order for a mediator to be appointed. So there is a step-by-step process that needs to be followed in order to ensure that the mediation follows through and we don't have even more protracted litigation.
Okay, I mean, obviously there are checks and balances, and thank you for speaking to, some of those fears that have now been allayed through your answer. I think just as we look at litigation strategies that also then get employed as a result of the introduction of this obligatory directive, how does that also play out in reality?
Well, I think the reality is that parties can still continue to delay the process.
Yeah.
If you're a plaintiff that is trying to proceed with a matter, get it to trial, and a defendant just doesn't want to cooperate, they are going to frustrate the process. They are going to delay it. But there is a special interlocutories court, SIC, that is being established to deal with these issues, to allow you to compel your recalcitrant opponent to provide the names of mediators, to participate in the process. And if they fail then to comply with a compelling order, you can then obtain a default judgment against them for failure to comply. So there are, coming back to what you said, Liesl, there are checks and balances, and there are ways in which you can force opponents to comply with the rules of court. So you're not just left to allow the process to be delayed and delayed and delayed.
Yeah. All right. So just as we wrap up, on the issue of inclusivity and accessibility, access to justice, and just using, the rule of law at large, do you think this is going to aid all South Africans? Is this going to better assist our democratic project as well?
There's some people that would disagree. There is already some attorneys that have challenged it and said that the process should be set aside, and that they're of the view that it won't assist the process. But I think something must be done. If we don't have the necessary judges and the volume of judges that are required to deal with the caseload, we've got to look at alternatives, and I think that mediation and forcing parties to really apply their minds, to really participate in the process, may go a long way to reduce the contested role and have those cases that really need to be decided in a court of law, decided in a court of law.
All right. Well, as more questions and answers remain, of course, we see the rollout of there. Thank you so much, Burton, for joining us and for unpacking that. We'll leave the conversation there. Director of Dispute Resolution Practice at Cliffe Dekker Hofmeyr Inc. Burton Meyer joining us more, of course, following the Judge President of the Gauteng Division of the High Court recently having introduced the compulsory mediation for all civil cases. And we'll obviously see how that's going to be playing out.